5 seconds to go. Start. The High Court has refused to accept the contention of the appellants that the dispute between the parties in any case is civil in nature. The High Court was of the opinion that since the appellants had claimed that the complainant assembled only 28,995 bicycles, which would make them liable to pay only an amount of rupees 35 lakhs, but instead the appellants had paid an amount of rupees 62 lakhs, which shows that the actual number of bicycles which were assembled by the complainant was much more than 28,995 bicycles as claimed by the appellants, and therefore the appellants had an intention to cheat the complainant right from the beginning. Thus, it was held by the High Court that prima facie a case of cheating is made out against the appellants. Having heard the learned counsel for both the parties, we are of the considered view that the findings of the High Court on this aspect are not correct. We do not agree with the findings arrived at by the High Court for two reasons. Firstly, the dispute between the parties is primarily civil in nature. It is, after all, a question of how many bicycles the complainant had assembled, and the dispute between the parties is only regarding the figure of bicycles and consequently of the amount liable to be paid. This is a civil dispute. The complainant has not been able to establish that the intention to cheat the complainant was there with the appellants right from the beginning, merely because the appellants admit that only 28,995 bicycles were assembled, but they have admittedly paid an amount of rupees 62 lakh 1,746 to the complainant, which is of a much higher number of bicycles, would not prove that the intention of the appellants right from the beginning was to cheat. This amount, that is the additional amount of rupees 26 lakhs, have been paid by the appellants pursuant to a settlement. The reasons and the logic for arriving at a settlement are quite different. In this case, it seems it is primarily to bring a quietus to the dispute and to have peace and to avoid litigation. The mere fact that the appellants have paid an additional amount pursuant to the settlement cannot be presumed as an act of cheating. Moreover, the complainant does not deny the fact that a settlement was reached between the parties, though he says he was coerced into the settlement. He does not dispute that the additional amount paid by the appellants under the terms of the compromise deed, which is an amount of rupees 25,75,442 after deducting TDS, was received by the complainant, as this amount has been received in a bank transaction through NEFT on 29 December 2017. The allegation that the complainant was coerced into a settlement looks unlikely for two reasons. First, there is no FIR or complaint that the complainant was coerced into this settlement. Secondly, this amount was duly accepted by the complainant. Stop.